Thank you, Professor Stearns. Thank you, everyone, for being here. It really is an honor to sit on this panel and to help celebrate the anniversary of our Constitution. Hello to everybody at home. Apparently, you guys are watching.
We're live streaming. Yes, we are.
We are live streaming. We wish you guys were here. I want to start by telling you guys just a little bit about some commonalities among the panelists here. It's really interesting just sort of talking with them before the panel this afternoon about how all of us have family members, parents that are teachers. And I do think just in the conversation that we've had that there is some spirit of valuing opportunities like this to get people, to get students, to get future lawyers excited about the law. And I think that that's what I hope to do a little bit here, and I know that Aaron and Rebecca hope to do as well. And so I want to make sure that we sort of save lots of time to hear your questions and sort of hear your thoughts about this. One of the things that I wanted to start out by doing is talking with you a little bit about the experience of being a law clerk. It's a really extraordinary honor. It's a great privilege. We get to work for these amazing, brilliant people who are tucked away in a building where nobody ever gets to see them. There's all sorts of funny stories about justices being mistaken for one another, for being mistaken for financial advisors, for, nobody really knows who they are. And it's hard to sort of pick them out of a lineup. And the work that the law clerks do is oftentimes shrouded in some level of secrecy as well. It's in part because we want to make it seem like we do a really, really important job, and if we don't tell anybody about what it is, it helps that impression. But I think it's really important for people that are thinking about the law to sort of understand how that process works. There are, believe it or not, about 8,000 to 10,000 cases every year where courts across the country are having litigants before them appeal their case, appeal their judgment to the United States Supreme Court. The Supreme Court, in the end, hears every year about 80 to 100 cases. And so one of the big functions of the Supreme Court is actually to decide in the first place whether your particular dispute will ever even be heard by the United States Supreme Court. And the law clerks actually play a role in that process. It's the only job for which we don't serve our particular justice, we're actually serving the court. And so they take, let's say, the 9,000 cases, and they split them up among the 9 chambers, plus the retired justices, so it's about 1,000 cases per chamber, and then they split them up among the 4 law clerks to each chamber or so. And so you end up with about 250 cases each. And what we end up doing is writing a memo. Sometimes it's a couple pages long, sometimes it's 20, 25 pages long, where our audience is actually all of the justices. And all of the justices have made it very clear to their clerks the types of considerations they want us to focus our memo on. And I thought it would be useful just for a minute to sort of talk with you guys about those considerations. For the folks that are law professors in the room, this is old hat. It's something you sort of hear and learn a lot about in law school. But for those of you guys who are in undergrad who are thinking about this, you ought to know what it takes to get a case to the United States Supreme Court. Because the Supreme Court and the justices on the Supreme Court like to say they are not in the business of correcting errors. They're actually acknowledging that of those 8,000 to 10,000 cases, because judges are human and because courts have human advocates before them, they make mistakes. But the Supreme Court's function is not to correct each of those mistakes. There's too many of them. What they have to focus on is a very small fraction of those cases that have certain features to them. One of those features is that the decision that is coming before them reflects some level of disagreement across lots of different courts. So when the highest court in Maryland and the highest court in California have a disagreement about a particular interpretation of the Constitution, that's when the Supreme Court says, you know what, this is a case where we need to iron out that disagreement. Because it's supposed to be one Constitution. It's supposed to be one document that governs us all. And as a result of that, it's very important for courts in Maryland and courts in California to have a common interpretation of that one document. So that's one consideration. The second consideration is that it affects a lot of people. It's one of the reasons why they don't want to necessarily accept cases which have so much to do with the specific facts. So you'll oftentimes hear these terrible wrongs that are done by criminals that get off on a technicality, or by police officers that have done something terrible and have abused their power, have gone in excess of their authority. And even when those cases work their way through the courts, it's very rare that the Supreme Court gets involved in that, because the right answer, and I put that in quotes, for a particular case like that has so much to do with the specific facts. It has so much to do with what somebody saw or what somebody said. And so that's not the type of decision that the Supreme Court's going to get involved in. It's got to be something that affects a lot of people, a lot of students, or a lot of citizens, or a lot of prisoners, or a lot of institutions, or a lot of companies. Those are the types of decisions the Supreme Court can use its sort of limited resources to try to weigh in on. And the last thing, and it's a really interesting last consideration, is it has to be a problem that's not going to go away. Sometimes there are statutes that are in place, but they know that the statute is going to sunset. It actually has a provision that means that the statute will end in a couple of years. And so it's not something, or a couple of months, it's not something that is going to be a repetitive problem for the courts. Or it's based on a technology that's about to go out of fashion. There aren't very many cases about typewriters anymore that make it to the Supreme Court. There are cases, more and more, about things like cell phones and GPS tracking devices and things that yesterday were not part and parcel of what law enforcement does, but today is a bigger part of the responsibility and activities of prosecutors and police going forward. So those are the types of considerations that they're looking at to decide what kind of cases they actually take. And I thought what I would do next was sort of give one example of a case that was before the court when I was there, that was very, very important to the court, very, very important, I know, to Justice Breyer, and was emblematic of, I think, his views on the responsibility and role of the court. And it's actually a really interesting case for students, because it actually involves students, high school students. It's a case called Parents Involved versus Seattle Schools. It involves two school districts, one of them in Seattle, Washington, and one of them in Louisville, Kentucky. And it was a case about what those school districts could do to voluntarily desegregate their schools. And the reason I mention this case is because Justice Breyer has a very strong view, a view that's reflected in his scholarship, a view that is reflected in his opinions, where he believes that the role of the court is to allow people to govern themselves. He is proud of the fact that he is rarely in the majority when they are striking down an act of Congress or an act of legislation by a state. He says in general, and he says in the book, if a state's representatives who have been elected by the people, or the federal government's representatives who have been elected by citizens of various backgrounds across the country, come together and they decide that this is the law that they want, it should be an exceptional act by this court to strike that kind of thing down. So although we can have competing interpretations of a particular sentence in that statute, or competing interpretations of what the original founding framers meant when they said something in one of the constitutional provisions, we should always remember that our North Star is allowing the people to govern themselves. And for that reason, I think this case was significant to him, because this is a circumstance where the Supreme Court was considering, and ultimately did, strike down and declare unconstitutional the decisions of citizens and school boards in Seattle and in Louisville, Kentucky. Justice Breyer dissented in that case. He wrote a vociferous dissent. He wrote a dissent that was 70 pages long. It was a long year. It was a long opinion. And it was a decision where he felt so strongly that he said actually from the bench, this is an opinion that is twice as long as any opinion I have ever written, but I have done so because it's very important to understand the history and the context and the law that came before this case, because this case turns all of that backwards. But a lot of that had to do with the fact that he was upset, and I think this comes across in his opinion, with the fact that the court was preventing people in Louisville, Kentucky, and preventing people in Seattle, Washington, from doing what they wanted to do. And what they wanted to do, and it's very interesting. How many of you guys are from Maryland? Like native Marylanders? How many of you guys are from Baltimore? Any Baltimore? So it's a really interesting phenomenon in Maryland and in Baltimore in particular, Maryland routinely every year gets an award for having the best schools in the country. And what's really interesting about our state is that there are some of the very, very best schools in the country, not that far away from some of the most troubled schools in the country. And Maryland and Baltimore, like so many school districts and so many schools across the country, have schools that are very, very racially polarized, schools that are all white or all black. This was happening in Seattle. This was happening in Louisville. It was actually regressing from the days of Brown versus Board of Education. And the school districts actually decided that they wanted to do something about it. So they put in place a program that would allow school choice, and they set up a system that would increase the racial and socioeconomic integration of these schools. They did it with great popularity. The citizens wanted it. The teachers wanted it. The parents wanted it. But nonetheless, even though democracy supported it, the Supreme Court struck it down. That was an example of something that the Supreme Court took because it affects a lot of people. It affects school districts across the country and students across all of those school districts. And it was also the type of decision that reflects Justice Breyer's particular view, which is that the Supreme Court shouldn't be getting in the business of telling school districts how exactly they want to achieve a good goal. And if their goal is increased diversity in their public schools, then how they accomplish it, how they decide they need to get there, is something that we ought to really leave to them, except in truly exceptional circumstances. So that's just a little bit of a flavor of what the Supreme Court does and how Justice Breyer thinks about these cases. And I want to make sure there's plenty of time for your guys' questions. So with that, I'm going to turn it over to Rebecca.